Let's start from the record. It reflects that the applicant was enlarged on bail in the present matter by this court on 20/04/2023 and against the order dated 20/04/2023 passed by this court. Informant of the case prepared special leave petition within bracket criminal number 6981 of 2023 before the apex court, and on 31/10/2023 the apex court set aside the order dated 20/04/2023 and remitted the matter to this court to take a fresh decision on the bail application of the applicant in the light of the observation made in the order dated 31/10/2023 para. Pursuant to the order dated 31/10/2023 passed by the apex court, the instant bail application is placed before this bench. The instant bail application is being heard with the consent of both the parties para. Learned senior advocate appearing on behalf of the applicant submitted that from the perusal of the order dated 31/10/2023 passed by the apex court, it appears that the earlier bail granting order passed by this court dated 20/04/2023 was set aside by the apex court only on the ground that while granting bail to the applicant, this court did not consider the criminal antecedents of 10 other cases of the applicant in detail. He further submitted that from the order dated 31/10/2023 passed by the apex court, it further reflects that finding on the facts of the case which was touched by this court by the order dated 20/04/2023 has not been disturbed by the apex court, and therefore he is only addressing the court with regard to the criminal antecedents of 10 cases of the applicant para. He further submitted that however the entire criminal antecedents of the applicant have already been explained in paragraph number 34 of the affidavit filed in support of the instant bail application, but in the light of the order dated 31/10/2023 passed by the apex court, applicant has again explained his entire criminal history in the supplementary affidavit filed in support of the instant bail application para. He further submitted that out of total 10 cases, 2 cases were of the year 2009, 1 case was under section 325 Arms Act and another one was under section 419, 420, 467, 468 IPC, and both the cases have already been withdrawn under section 321 CRPC in the year 2019 para. He further submitted that out of remaining 8 cases, 3 cases were under section 174A IPC relates to case crime numbers 375 of 2020, 265 of 2021 and 12 of 2022, and as per the offence under section 174A IPC no FIR could be lodged. Therefore applicant moved to discharge application before the trial court in 2 cases of the year 2020 and 2021, and when his discharge application was dismissed, then he preferred criminal revision before the sessions judge concerned, and revision filed by the applicant was allowed by the concerned sessions judge, and matter was remanded back to the trial court by the orders dated 25/08/2023. The matter is still pending before the trial court, and in third case, which is of the year 2022, applicant has already been released on bail and his trial is still pending para. He further submitted that however applicant was also made accused along with his father Vijay Mishra in a case under section 376D, 342 and 506 IPC relates to case crime number 379 of 2020, but in this case applicant has been acquitted by the trial court by the order dated 03/11/2023. However, why Vijay Mishra, the father of the applicant, has been convicted for offences under section 376 (2) and 506 IPC, he further submitted that the above noted case was a well contested case and applicant was acquitted by the trial court after analyzing the evidence of the case, and this fact shows that in that case applicant was falsely implicated para. He further submitted that out of remaining 4 cases applicant was also made accused in 2 cases of Arms Act of the year 2021 and 2022, and at the time of lodgement of the FIR of the case of the year 2021 applicant was in Mumbai, and when he came to know about his implication then he immediately released his video from Mumbai. But in spite of that, in this regard no investigation was conducted. He further submitted that this case was lodged by the STF. He further submitted that as far as case relates to case crime number 230 of 2022 under section 3(7)(25) Arms Act is concerned, in this case also applicant was falsely implicated on the basis of planted and illegal recovery of weapons. He further submitted that in both these cases of Arms Act the bail applications of the applicant are still pending para. He further submitted that on the basis of false cases applicant has also been made accused under the provisions of section 3 within bracket 1 IUP Gangsters Act and trial of the case is still pending. He further submits the applicant is not a gangster and he never indulged in any antisocial activities, and by misusing the provisions of UP Gangsters Act he has been made accused para. He further submitted that the last case is for offences under section 120B, 147, 149, 307, 323, 392, 452, 452, 504, 506, 511 IPC relates to case crime number 194 of 2021, and this case was lodged by the informant of ... case in which applicant has already been acquitted. He further submitted that this case was lodged by the informant of ... case only to create pressure. He further submitted that the trial of the case is still pending para. Learned senior advocate appearing on behalf of the applicant submitted that all the above 10 cases which were lodged against the applicant were lodged due to political reasons, and only being son of ex-MLA Bijoy Mishra applicant was made accused in all these cases, and except the 2 cases which were of the year 2009 which have already been withdrawn by the state. In other 8 cases applicant was made accused after lodgement of the FIR of the present case. He further submitted that out of total 8 cases there 3 cases were of section 174A IPC, and these cases were lost only due to the reason that the applicant failed to appear before the court concerned. He further submitted that applicant is not an absconder, and due to fear of his life he could not appear before the court concerned.